Good morning. It is June 25th at 8:31 a.m. This is a special docket of notices of violations only. My name is Gregory Chikalian. I'm the hearing examiner. Our system is a little bit odd this morning, so I'm appearing through my laptop here in Pecos Hall. Okay, I'm going to call the first one a little bit out of order. This is Echo Production. This is 26039. Entries of appearance, please.
Michael Hall on behalf of OCD.
Good morning, Mr. Examiner. Dana Hardy on behalf of Echo Production.
Good morning, Mr. Hall and Ms. Hardy. Before I begin, Mr. Hall, just use your computer mic, not that mic.
Gotcha.
Okay, good. All right, excellent. Okay, Mr. Hall.
Yes, if Ms. Hardy will agree, we have an agreement. However, in fact, Ms. Hardy's client has signed the stipulated final order. We're awaiting the director's signature, so thus we haven't filed a motion to dismiss because the document is not fully executed. However, we have an agreement.
Ms. Hardy?
That's correct. We've signed the agreement and are just waiting on the director's signature and then dismissal.
Okay, so Mr. Hall, it's my understanding that once you get a signed stipulated final agreement, that you file a motion to dismiss with that as an attachment and then a proposed order dismissing the case.
Correct. There will be two exhibits, and those are the two exhibits.
Okay, very good. Okay, I understand what the posture of this case. Thank you, Ms. Hardy.
Thank you,
Mr. Hall.
Thank you.
We're off the record in that case. Okay, now I have here that I'm going to call another case out of order. This is Coulthurst MGT, case 25940.
Yes, Michael Hall on behalf of OCD, President Ready. And I do want to announce to you that I had a conversation with Mr. Swallow about this case yesterday, which I'll let him elaborate on. But anyway, that's just want to make you aware of it.
What I'd like to know from the division is, it's your case. So what is your intention? Because today was the final status conference.
I understand. My intention, they filed a motion to continue for continuance. I do not oppose, the division does not oppose that, for the reason that we believe there's some moving parts to this, including BLM involvement, and Mr. Suazo has let me know that they've recently got a lease extension, which was sort of a touch and go matter. And now they're negotiating with another operator regarding bringing the wells into compliance. Our position is we're ready to go today, but we've agreed to Mr. Suazo's continuance in an effort. What we don't want is an order saying OCD can plug when an operator's planning on doing. So that's sort of our considerations. And we also we have a settlement as to the amount of civil penalty. So that's,
Okay.
want to announce that. We do have that agreement. There's not enough certainty as to what's going to happen with the three wheels. There's a plan, but, there's not concrete deadlines at this point. So that's not ideal, but it's okay with us because there's been progress. So certainly it's in your sound discretion what happens, but that's OCD's position on it.
And I want to know what your position is. Thank you. Mr. Suazo?
Yes, good morning, Mr. Examiner. I appreciate you indulging our motion for extension. I wanted to provide a little color, since we were last before you on this matter. So we do have a firm deadline from the BLM. That was something that was kind of hanging, and they had initially taken the position that they're going to cancel the lease. They've backtracked from that, and they've set December 1st as the deadline for our client, Coulter's Management, to actually plug or produce these wells. And so as soon as we got that date on the horizon, Mr. Coulter's was able to speak to a actually, credible and licensed operator that has deeper resources than he does. He's an elderly. And so it looks like they're still in the process of conducting their due diligence. We're optimistic that an agreement is going to be signed in the near future, but ideally, I think the outcome for the division and for the state is that an operator take over, the P&A obligations here through this process versus the state having to use their resources to do it. And I think while there's still the opportunity for that to happen in discussions with Mr. Hall, we'd like to try and make sure that that is at least, a possibility and hopefully likely.
Okay, I understand. So, Mr. Hall, give me some information here. Give me some information here. What was alleged in the NOV?
3 inactive wells. So that's it. It's been some time. I'll have to pull it up. I'm sorry I had to restart my computer, but yeah, let me pull that up. As to the dates of inactivity is what I could give further detail on. But yes, 3 inactive wells. That's essentially we're based upon our standard formula. We're asking for 1,350 in civil penalties. In the NOV, Mr. Swat, or the operator, and OCD have agreed to $1,000 on that. That's really it. It's 3 inactive wells. So it's on BLM land. There were some issues. I think the lease was either had expired or was expiring. And Mr. Suazo was letting me know that that's no longer a concern, which I think that was sort of the first hurdle that the operator needed to get over. So let me pull up that NOV and I will let you know. I think it's a substantial time frame for inactivity. So we're glad to see progress, but September of 2020 they've been inactive since at least that time. So,
And when did you serve the NOV on the operator?
on or about January 27th. It's been some time for, just to give you some more supporting detail. Mr. Suazo has not been involved in this case since that time. The last couple months, I want to say, I don't know exactly when he entered, but I personally had dealt with Mr. Coulthurst, who's correct. I think he's almost around 90 years old. But he was actually a pleasure to deal with and was concerned about this and wanted to address it from all impressions I had. And in fact, I think is indicated by hiring counsel has taken efforts to do that. So
What I'm trying to understand here, and Mr. Suazo, maybe you can help me with this, is there any maybe I should ask this in a different way. Does your client admit that these 3 wells have been inactive since September of 2020?
Yes, there's no dispute with that. I think it's just one of those things where he lost track of some assets, and he's working really hard with this other company to try and get things to a better place because he just can't do it with his age. And so it's been interesting working with him. But I will say, they've been showing us communications between, my client and the actual operator, and they seem like they'd be done in good faith. We have a list of all the remedial actions are going to take and all these kinds of things. So we're trying to make the situation right as best we can.
Okay, no, I understand that, and that's a different issue that I'm trying to deal with right now. So I guess what I'm wondering, Mr. Hall, is if the client, if the respondent does not deny that what is alleged has happened, why not draft a stipulated final order that says, I admit that these 3 wells were inactive. I will pay the $1,000 penalty, and I have a certain amount of time to finalize this agreement with this operator that I don't know who this operator is, or the state will be responsible for plugging these wells. Why do we have to keep going with this case is really what I'm asking.
Well, I think the uncertainty as to timeframes would be the division's concern with drafting that right now. It could be done, and we could maybe just give a little more time. The state doesn't want, we don't want the state to be responsible.
Sure, of course not.
The operator to be responsible for the successor to this operator, whether it's through a full purchase or transfer of wells. So, I think that is something, it's something Mr. Suazo and I discussed yesterday. I didn't think there was enough specificity to do that, but I think we could get together and do that, but I feel like I'm in a position to negotiate that on the record right now, and that might be difficult to do. We have had discussions. There's not enough specificity as to what or time frame. Now, there's general time frames, but that's my concern with doing it stipulated. There's not concrete deadlines that we know right now to put in there.
If I may.
Yes, go ahead, Mr. Suazo.
So I guess, we do have kind of a firm deadline on the horizon. So, that's one reason. I think another reason is that I don't know the nature of this company. I mean, I know it's a reputable operator as far as I can tell. But, I think the concern is that if the NOV is issued and the order is signed, that makes Mr. Colthurst, somebody with a ding on their record, so to speak. So I don't want that to gum up any of the negotiations because I don't know what their due diligence process is. And I think we're moving in the right direction. So all we're asking for is, a bit more time to get this done. And if we don't, there's nothing stopping the division from, levying the fine and issuing the order at a later date, given the time frame we're currently looking at.
What is that time frame, Mr. Suazo?
So December 1st is the hard deadline for the BLM, but obviously we need to get things in order well before then for that to even matter. I think the delay at this point is that they're struggling to get the title committed so they can confirm what is owned and if there's any clouds on that title. That process typically takes longer than you would think. And then based upon that, they need to put together the agreement, the scope of work, they need to line up the contractors. All those things from what I've seen are things that they are doing. But again, it's, something that takes longer than you might expect if the, constraints are OCD hearing deadlines.
I'm having a problem with, let me turn off this microphone, this speaker here because there's an echo. I'm having a problem with the delay in resolving the remedy. It sounds like there's no dispute over the wrongdoing. That is what it is. There's no dispute over the fine. That is what it is. The question is who's going to plug the wells. That's really what we're talking about, right?
Slightly.
Well, tell me where I'm
one Mr. Suazo can certainly correct me. He has more information. My understanding is the plan is to actually produce or make an injection well at a couple of them, and one's probably going to have to be plugged. But I think that's part of what they're working on. I'll open that up to Mr. Suazo, who has more information on that.
But okay,
it's not necessarily only plugging.
I guess is what I would inform you.
Okay, so let me rephrase.
Mhm.
The only question here is the disposition of the wells.
Correct.
Whether they're plugged or produced,
Correct.
they're certainly not going to be produced by Mr. Coldhurst. That's obvious, right?
I'll
Correct.
let Mr. Swazo speak to that.
Well, I mean, I guess he could try, but that's not the
That
plan right now.
comports with my understanding.
So are you telling me that you can't draft a stipulated final order that deals with the allegations being true, deals with the fine, and then as I remember your orders, there's basically what happens after. And why can't you and Mr. Swazo draft what happens after to leave things open that either this other operator takes over the wells or the state plugs them? Why can't that happen?
I can do that. However, I would be granting longer extensions to get wells into compliance than
Okay.
I normally would.
Okay. I mean,
That's really the only problem. And normally they say, I need 3 months to get this done. And I'm like, okay, that comports with our policy on that.
yes,
But we're not at that point yet.
because this will take longer than 3 months.
Yes, there's some, I think still, for instance, title work apparently that needs, so there's some uncertainty there. I can draft that.
But there's no uncertainty that Mr. Coulter's owned the wells that have been inactive since September of 2020, and that there's a fine that goes with it. There's no dispute about that.
Correct. No, I think we're all in agreement that he was, I don't want to say him, his company was not compliant.
Okay.
And so
Okay.
that's undisputed. I think Mr. Swazo just agreed to that.
So, Mr. Swazo, I'm not willing to wait. I mean, this was filed in January. I realize that you got involved along the way and not from the very beginning. But I'm not willing to wait months for the title to be figured out and for you to potentially come back to this tribunal and say, oh, well, there is no, they're not, the new operator is not comfortable taking over the 3 wells. So we'll just proceed. So give me an option that we can wrap this up in some fashion within the next 30 days, no matter what.
I think it's going to be challenging to wrap this up in the next 30 days, which is why we asked for a, more extended status conference timeframe. I can't control the negotiations between the parties. We've offered to help facilitate, but, the other company has their own counsel who operate on their own timeline, and they're not really, focusing on the division as we are. I think that what we could do maybe, we could agree to the $1,000 fine and update you within 30 days, but I also don't want to waste your time coming back in 30 days, with essentially the same update. I do think perhaps maybe it's fair if we extend this 90 days. And I think at that point, we'll know if this is going to go or, if, we just need to move towards, issuing the order and paying the fine and driving down the road. But I don't know what to do in the next 30 days, frankly.
Okay. All right. Thank you, Mr. Squazzo. So, Mr. Hall, having this on the docket for 9 months is just not acceptable. So we can't do that.
Understood.
So please come up with some creative thing that maybe what we could do. I mean, obviously you could always dismiss your case and bring it back. That's one idea, right? I mean, you could do that.
That could happen.
You could do that.
That's not our preference.
And I'm not forcing you to do that. I'm
Sure.
just suggesting that's an option. The other option is to do some sort of an agreement between the parties that the director can sign off of that leaves the disposition of the wells somewhat open. I know it's not your preference to do it this way because you have a time frame, but this is a different kind of a case.
Agreed. And my suggestion, I think I have it muted since I'm using my computer. Can y'all hear me? No, I don't have. There we go. Okay. My suggestion is,
I know Mr. Suarez said he might not know anything in 30 days. Reset this for the next docket, which I think is July 21st.
Okay.
And if it's not resolved by then, we either do an SFO or we have our hearing.
Okay.
And we'll
I'm fine with
present
that.
our evidence to you. And so
Okay.
30 days, I think, I would hope is enough time for them to have more details on what's going to happen with these 3 wells. And if they don't, I don't disagree with you that maybe we ought to just enter an order and then see what happens from there. So that's my suggestion. I know it's not as long as Mr. Swazo wants, but we're certainly agreeable to a 30-day reset to give them just a little more time to get their ducks in a row.
Okay. Or the other alternative is that you and Mr. Swazo be creative
Sure.
about some sort of a stipulated final order that, again, agrees to the violation, agrees to the fine, and then in some creative way, I mean, you're lawyers, in some creative way, leaves you some leeway to allow this operator to take over these 3 wells or 2 wells or whatever the wells that they're going to.
Sure.
And we'll plug the other ones. Mr. Swazo, anything further?
No, Mr. Examiner, I understand the position of the division, and I think that is fair, and we'll deal with the 30 days as it comes at us and hope for the best.
Okay, Mr. Swazo, thank you.
Thank you.
Mr. Hall, anything further? We're off the record in this case. All right, let's call now Buffco Productions. This is 25931. Entries of appearance?
Yes, on behalf of OCD, I have another agreement to announce. This is also awaiting the director's signatures. Buffco is they've really made ton of efforts to have one well to get it plugged.
Yeah.
And it's extenuating circumstances out of their control why that hadn't happened.
Okay.
They have shared all these details with me. And
I haven't heard anyone from Buffco. Am I not going to hear anyone?
I don't know. I told them the hearing was happening. They have signed off on the SFO. However, I haven't gotten it back from the director yet.
Who have you been speaking to at Buffco?
A lady named Brenda Kesterson. I hope I'm not butchering.
Is she here?
Don't see her.
I wanted to give time for someone to enter an appearance before you.
Sure. Sure. That's I suspect they're not here because they signed the SFO yesterday and consider this resolved.
When you're dealing with respondents in the future, if there's a case on our docket, please encourage them to appear, no matter what, whether they've signed something, not signed something, whatever it may be.
And you've given me that instruction before, and I'm going to take the hit
on this one. I don't think I told her that yesterday. So my apologies to you.
All right. So
I'm going to make that a habit.
All right, good. So she's not here, but you have a signed agreement, and the director has that for his endorsement.
Yes, and in fact, even further, I have. This was a little bit of a unique case because of.
You need to take a moment and look at that.
I'm just giving Sheila feedback. So can you hear me? Okay.
I hear you perfectly, but I'm 2 feet away from you.
Well, I know, but I wonder if the record's picking me up. Anyway, so this one I've even checked with the director, and he's fine with the like. I don't always ask him before we do an SFO. This one's another long one.
Okay.
But it's not their fault. They're trying to get it plugged, and they have from the get-go.
Okay. So you're waiting on the director's signature.
Correct.
Once you have that, the case can be dismissed.
That's correct.
Okay. Then we're off the record in that case.
Okay.
All right, the next one on our docket is David Hammond. This is 26033. Entries of appearance, please.
Michael Hall on behalf of the Oil Conservation Division.
Okay, and do we have someone from David Hammond? Mr. Hall, who have you been communicating with?
I have not spoken to anyone. There's 2 emails. One bounced back, the other did not.
Okay.
And so, but no one has reached out to me.
And there's no one here today. Why don't we have our hearing and go right ahead?
I would offer exhibits 1, 2, 3, and 4 associated with our pre-hearing statement.
You'd offer them into evidence?
I would offer them into evidence.
All right.
Yes, sir.
They're admitted without exception. The respondent has not appeared at the hearing and is in default based on not appearing. How would you like to proceed?
I would like to proceed by drafting an order setting out all the relief prayed for in the NOV.
What is the relief?
Let me pull this one up. Sorry. think it's one well, but don't quote me on that.
And if you could say what the allegation is on the record.
Sure, it's inactive wells.
One
That I
inactive.
can say for sure. And let me just let you know the amount, number. 2 wells. So 2 wells, so it's a $900 civil penalty we're seeking. 2 wells, we're seeking authorization to terminate their authorization to transport, the ability for OCD to plug those wells, all other relief set out in the NOV.
All right. Okay, so you'll send me a proposed draft order.
Yes, sir.
All right, very good. All right, then we're off the record in 26033 as David Hammond has not appeared, and no one from David Hammond has appeared. Okay, let's move on to DeLong. This is 26037.
Yes, Michael Hall, present, ready to proceed on behalf of OCD.
Would you unmute your microphone, Mr. DeLong, and enter an appearance, please? Who have you been communicating?
I believe this is probably him. I haven't seen him, but Buddy DeLong. is
Buddy
his
DeLong.
name. Yes.
Okay. Can you, Madae, can you unmute his microphone? I understand. All right. Mr. DeLong, can you hear me? Mr. DeLong? This is a very odd situation, isn't it?
It is. He's here.
He's here, but he's not
He's
announcing
not here
himself.
also.
Well, we can see Mr. DeLong. I don't know what he's doing, but Mr. Hall, go right ahead.
Sure. Yes, I have been in communication with Mr. DeLong. Was optimistic at one point that we would enter an SFO, but the division is not satisfied with the progress
Okay.
that's happened.
Then
since
go ahead and present
February.
your case.
Very good. Yes, just for, well.
You don't have Mr. DeLong's phone number, do you?
I don't know. Let me pull up email, and see if
Thank
maybe
you.
that's in there. We've emailed to, we might have had a phone call, kind of way back there. Let me see what I have.
Sure.
Well, now it says Horace DeLong. This one does.
Oh, Horace
It may have
DeLong?
2 names, but it says Buddy DeLong.
Okay.
Yes, I do have a phone number.
All right. Madae, do you have a phone? Do you have a work phone with you? Would you read the number, Mr. Hall, so that Madae can call Mr. DeLong?
Sure, you ready, Madae?
Okay, it's 575-513-0472.
0472.
I'm sorry, I couldn't hear you. Oh, I'm sorry.
0472.
Let's see what happens, Mr. Hall.
Okay. Yes, I would prefer for him to be able to hear
Me
everything.
too.
Given that, and it may be the same, my request is that we come back to Mr. DeLong at the end, just so
Okay.
he's here and has a chance to participate to the best.
I have no problem coming back to Mr.
thank you.
DeLong. All right.
The rest are, I think,
Okay.
gonna either be announcements or.
All right. Let's move on. We're in recess on Mr. DeLong's case. Let's move on to Enerdine. This is 26040.
Yes, this, pleased to announce this is another SFO that has been signed by the operator.
Okay.
That's awaiting the director's review.
And what's the
signature.
allegation here?
Let me pull that one up. It's inactive wells for
Okay.
sure. I think it was several, and I also will announce that.
Marty, can you send a text to that number? Let him know we've called his case and we're waiting for him to unmute and announce himself.
So Mr. Don Hanash is who I've dealt with on this.
Yes.
Operator has 19 wells, 6 of them were out of compliance and inactive. I want to say it's 5 that he had already done C103s, had approval for plugging, I think on all of them, if not all of them, almost all of them. He has plugged a lot of them. And I think he has one left to go. Anyway, the SFO, we've given him a couple more months to do that. He's already paid the civil penalty. That's already been received by the division.
Okay, so the SFO is with the director. Perfect.
Yes.
And you'll dismiss this case. All right,
Correct.
very good. We're off the record in Enerdine. Mr. DeLong, can you hear us? Wow. How strange.
Yeah.
How very strange. I wish there was a way to communicate with him through the computer since he's looking.
Can we chat maybe in the hearing?
Doubtful that he knows how to do that.
Yeah, that's would agree. Mr. DeLong, can you hear us? Mr. DeLong? I don't know.
You sent a text? You did send a text. Well, maybe this is a strategy, Mr. Hall, that we haven't quite seen yet before. But I'll wait till the end to call the case.
Please, thank you. I appreciate your indulging me.
Although I have a feeling nothing's going to change. Okay, let's now go on to Finally Resources. This is 26042.
And I apologize. There's an SFO that's fully executed in that one.
Which one?
Finally Resources.
Are you going to enter an appearance?
Yes, sorry. OCD present and ready to proceed.
Yes.
Want to announce to you that yesterday we filed a motion to dismiss with an order with the attached SFO in this matter.
Okay.
So
you did.
It's
Okay.
ready for you to sign off on.
Okay.
Sometime back we had executed the SFO and I had not filed the dismissal on that yet. So it's not Mr. Finley's fault. It's mine.
And Mr. Finley is not here with us.
He is not here,
Okay.
but I can understand why.
I can understand why too. Right. Okay. So moving on so we're off the record in Finley Resources. So moving on to George Denton, 26066.
Yes, OCD's present and ready to proceed.
Okay. Is there anyone from George Denton? Go right ahead, Mr. Hall.
Mr. Denton, I have been in touch with him. In fact, he has plugged the well. I think there was maybe, this isn't part of the NOV, there was maybe some sucker rods still out on the site that needed to be cleaned up. I think it was 2 days ago I spoke to him and he said either that had happened or was about to happen. I think he hired someone to do it. At any rate, the allegations in the NOV have been addressed by him.
Okay.
I've been speaking to our engineering department and they're satisfied. And there's some extenuating circumstances which I don't really want to go into detail on the record regarding Mr. Denton's health, but our OCD would like for there to be no civil penalty in this case because we're satisfied with he got on the work.
Okay.
And there's good reason for us not to.
So are you presenting the case today?
Yes, we're
right
going to
ahead.
present the case and he knows we are.
Go ahead.
Okay, we would offer exhibits 1, 2, 3, and 4 attached to our pre-hearing statement.
Into evidence.
Into evidence.
Okay. So those are admitted without exception as there is no one here to object to them. Go ahead, Mr. Hall.
Yes, we seek really a standard order authorizing us to seek the relief in the NOV, but really that's not necessary because the well's been plugged and we seek no civil penalty. We really just want an order acknowledging that he was in violation and enter that, and I'll be happy to draft
You're
that.
drafting that.
Yes,
Okay,
sir.
very good. Then I'll wait for your proposed order. And we're off the record in George Denton. Let's move on to H&M Disposal, 26072.
This is another SFO case.
Okay.
Let me double check on this one because I don't know if I've gotten this one back, but we have agreed in principle to the terms of it. Let me double check that.
Marty, will you try calling the number again? Maybe you should leave a message this time. That we're gonna proceed with the case whether or not he announces his presence as he's here. We can see him. He looks at the screen. So I don't know what's the matter.
H&M, I would like to go ahead and proceed. I have not received the SFO back.
Okay.
If I do get that back, we may end up presenting you with the dismissal instead of an order.
I get
But
it.
given that I haven't gotten that and haven't heard back on that, I would like to go ahead and proceed. And I think they have notice of the hearing.
Right.
So
And who is that? Who is it there at H&M that you've been talking to?
let me. Sorry, I closed that down. Let me. Harad, I believe is his name. Yep.
Okay.
I hope I'm not saying that wrong. And this is, I don't think we've spoken on the phone. I think it's all been through email.
This is why I really like, if the case is on the docket, I'd really like to have the respondent
I
here.
understand,
Yeah, I know
yeah.
you do. I'm just saying, this is why I'd really like to have them there.
Yep.
So go
And
ahead.
I'm disappointed we haven't gotten the SFO. We're still willing to abide by that, but
you
in the
mean you
event we
haven't-
don't, we would like to
Do you mean you haven't received the signed copy back from the
even from the
respondent?
operator. We're
That's-
not waiting on the director on this, and that's why I want to go ahead.
Go right
and-
ahead.
Okay. Yes, Michael Hall on behalf of OCD, we're ready to proceed and would offer into evidence exhibits 1, 2, 3, and 4 attached to our pre-hearing statement.
Admitted without exception, as no one from H&M has appeared. How do you want to proceed? You want to draft a,
I will draft a proposed order or a motion to dismiss,
right.
depending on how the operator deals with this.
How long are you willing for the operator to sign the SFO?
I don't think, honestly, I'm disappointed it hadn't happened. I'll probably give them a week,
Okay.
and then I'll go ahead and we'll proceed
Okay.
under default,
Right.
because they didn't show up.
Was there some sort of bargain, benefit of a bargain that he was going to get in the SFO?
Not really.
Okay.
No, there's nothing unique about it. Yeah.
I just wondered. All right, Mr. Hall, thank you. I'm going to
Thank you.
recall DeLong. This is case number 4 on our docket, 26037. Mr. DeLong? Then he should just call in. All he has to do is unmute. We can see him. Hearing us. So it's his microphone. Yeah, just have him call in. Go right ahead. Let's take a 5-minute recess while you do that.
Are you still there?
So I turned off my
Well, I unmuted mine. I have my
Yeah,
mic
sure.
unmuted right now, but they're not responding to it.
Oh, my mic my
Can you hear me?
speaker's off. I don't know. Yeah, let me camera.
Can you hear me on the computer?
I don't hear you on the computer at all.
Okay, so I'm just gonna give you the number so you could call in.
Okay. I think according to that notice, it is 505-312-4308.
Give me 1 second. 'Cause
Okay.
I do not know it. Dial in. It says 505-312-4308.
Okay, that's what it says here. Okay, well, maybe I could just stay logged on and then do I enter that 732-643 phone conference ID?
So
Okay, I'm gonna go ahead and I'll causing feedback. All right, I'm on the phone and I think I should have the mic muted now.
It's on my list and all this stuff's getting back now.
Hi. Can you hear me now?
Thank you. Yeah, I hear you great now. Thank you.
Okay, perfect. I'll let the hearing officer know. Give me 1 second. And we'll get back to your case. Thank you.
Okay, Mr. DeLong, are you with us?
Yes. I thought you guys were just having, I just thought I was just not privy to any of that. So I was just waiting for my audio to come up.
Yeah, okay,
So
we called your,
I've been on for about 48 minutes and I thought, well, I guess the meeting hasn't started yet.
no, we called your case. It was the fourth one on the docket. We called your case about half an hour ago. We could see you, but you weren't unmuting your microphone and speaking to us. So we just held your case in abeyance while we found a workaround. So I'm glad you're with us. And Mr. Hall, how are we proceeding on this case?
OCD is present and ready to proceed
Okay.
with the hearing.
Go ahead.
Thank you. Yes, this is an inactive well NOV. Here, let me get this. Inactive well NOV. Let me pull it up.
Let me ask Mr.
I think it's
DeLong.
one.
Mr. DeLong, did you receive the NOV?
I did not receive it until I believe maybe 60 days ago. It was I think according to the stream of documents, it was sent to an old address.
Okay.
And I sent Mr. Hall like an assignment of where I had sold those wells back in 2021.
Okay.
And so I'm just coming back into it right now.
Okay. Okay, so Mr. DeLong, we'll get to the evidence in a little bit. I just wanted to know if you got the NOV and if you had read it, and do you understand it?
I'm sorry, I'm getting a bunch of echo.
Maybe because you have, I don't know why you're getting echo. I guess I really don't know. If you're on your phone, so
Okay,
Mr. Hall, is your microphone muted? That may be why he's getting an echo. It is muted. Okay, Mr. DeLong, how's this? Is this better?
Yes, that's much better.
Shoot, I can't hear him now. Will you say that again?
Can you hear me?
Yes, I can hear you perfectly, but can you hear me?
Great. Yes, sir.
All right, very good. Mr. DeLong, did you read the NOV and do you understand it?
Yes, I certainly do.
Okay, very good. All right. So now Mr. Hall is going to present his case. He's going to ask, and I'm just going to give you some procedure of what happens here because you're not a lawyer. Are you a lawyer?
Certainly. No, I'm absolutely not a lawyer.
All right. Mr. DeLong, Mr. Hall is going to present his case. His case consists of exhibits. And Mr. Hall, did you send the exhibits to Mr. DeLong?
Yes.
Okay. All right. So Mr. DeLong, there is a pre-hearing statement that sort of lays out the case, and then there's exhibits that go with it. Did you get that?
I don't think that they were ever sent to me. I found them through the hearings. I went onto the OCD site and I found out. I researched it. I found it myself.
I understand. So are we sending things to the wrong address?
I changed the address whenever I found out that I was still the operator.
Right.
My address should, so, but I don't have anything. And I think I asked whenever I got an email, I did get an email that sent this, and then that's when I started inquiring. And then I talked to Mr. Hall, and so then since everything is put up on the site, I was able to see.
Right.
I don't have it all in front of me right now, but
okay.
But I'm aware of where the state is on that, and
okay.
And so I'm just here to see what we can do.
Okay, sounds good. So, Mr. Hall, it seems like there's some problem with mailing things to Mr. DeLong.
I've been in communication with them. by
Okay, you have.
email.
Okay.
Yes.
All right. Mr. DeLong, Mr. Hall didn't realize that you didn't get the pre-hearing statement and exhibits, but because you're capable, you have them. So that's what I was concerned with. So what happens at this point, Mr. DeLong, is that Mr. Hall puts on his case. You have a right to cross-examine any of the witnesses that he presents. Now, the witnesses he's presenting today are in the form of an affidavit, but if you want to question them, you can do that. Okay?
Certainly.
All right, very good. Mr. Hall, go ahead.
Yes. OCD would offer exhibits 1, 2, 3, and 4 attached to its pre-hearing statement.
Mr. DeLong, do you have any objection to those exhibits being admitted into evidence?
No.
Okay, very good. Mr. Hall, your exhibits are admitted through stipulation of the respondent.
Great.
Okay, now, Mr. DeLong, would you like to cross-examine any of the witnesses that drafted those exhibits?
No.
Okay, very good. So, Mr. Hall, I'm sorry. Mr. Hall, do you rest your case?
Yeah.
Okay, very good. Mr. DeLong, this is your opportunity now to present a case. If you would like to present evidence to the division, there's two ways of doing it. There's sworn testimony, and then there's documents. Now, I'm assuming you did not file a pre-hearing statement. Is that correct?
No, I did not. Mr. Hall should have, that I forwarded to him. The only document that I have in support of, he
Okay.
has received an email from me that was an assignment that I had, I don't know if you're aware of that.
Okay, I'm not yet, so I'm going to talk to Mr. Hall, but okay, so you have submitted a document to Mr. Hall. How long ago?
Yep. I would just have to, I'm going to say it was probably a week ago to 10 days.
Okay, okay, fine. Mr. Hall, did you receive a document? Oh, very good. And Mr. Hall, what do you make of the document? What is?
Mr. DeLong,
Sure.
predicament. Fortunately, under the rules, DeLong LC
I see.
is the operator that's responsible for this inactive list.
So what is the predicament?
OCD has no predicament.
I know that. You said you were sympathetic to Mr. DeLong's.
It was never transferred in OCD, and we don't get into ownership, title issues. We go by who is the registered operator for this well with OCD. That is who is responsible for the plugging and abandonment of the well.
So what is the allegation in the NOV?
LC, the operator, has one inactive well and has been continuously inactive since at least October of 2020.
October of 2020. And Mr. DeLong, you said you sent the document showing some sort of a transfer. When did the transfer take place?
Well, I wish I had the document with me, but it's a oil and gas assignment. Well, it's a oil and gas assignment dated, and Mr. Hall has it. It's just a county recorded assignment, and that date's on there.
Okay, hold on, if you don't have it, Mr. Hall, I'm sure has it. So give me a minute.
It's an assignment, conveyance, and bill of sale. Again, I don't, it appears it was recorded with the county clerk. I haven't verified all
I know.
but, and it appears the date is 11th of January of 2021 is when, it was notarized.
I see. So in other words, so Mr. DeLong, what you are asserting then is that you were not inactive past that date. Is that what you're saying?
Oh, you know what? It could have been. It's 5 years ago, but and I understand how it works. Where I should have checked back in to make sure that I was selling out, moving to Texas, and when you don't hear anything about it for 5 years, I've came in, I've worked on the well. There's still a few things that I need to do to it, but you can turn the well on and pump oil right now, but I've got to put some new equipment on it because the operator, the L&J oil, let everything just degrade. And so I can't risk a leak. And so I have to replace all the tankage.
But the reason that okay, I'm just dealing with the transfer of the asset. The reason you sent that document to Mr. Hall was for what purpose?
Well, the purpose of it was just, I know we have procedure and then we have merit. The crux of it is I really didn't believe that, I believe that L&J Oil was moving ahead, doing what they were supposed to do. And, the procedural aspect is like, I have been the operator for the last 5 years, and I understand that. I understand how the rules work. Now I've been made aware that I was never not the operator. Now I want to rectify that, and I need to try to do that and still not get sued by the bank that's holding that well record title as collateral. And so it's I'm walking the edge here. I want to do what's right with the state, without something else blowing up in my face.
I get it, but I'm still trying to understand in your own words why you sent that document to Mr. Hall a week ago. What was the purpose? What was in your mind that you sent that document?
Well, I just wanted to show Mr. Hall that the intent was to convey all right title, ownership, and operations. And I don't know why. I know that he provided a bond. He provided a bond, federal and state. And so I thought he was, I really thought, because I wasn't going to sell to anybody that didn't have bonds, didn't have accepted bonds. And so when he showed that he had the bonds, I made the assignment, and I guess there's no mechanism to other than just going back and doing some post diligence and say, did all of this get conveyed? I had no way of knowing that until I get contacted by the NMOCD. So I'm acknowledging that I've been the operator, I guess, the whole time. The human part of it is I assumed, I truly believed that L&J Oil was going to be, and I don't know whether it was a failure of getting it done, or whether the OCD rejected it, or for whatever reason, it still wasn't done. So
okay, I understand, Mr.
For whatever
DeLong.
the reason it didn't get done or immaterial, I understand that right now I've been the operator and I've been responsible.
Okay, so Mr. DeLong, what I think I understand from you, although you haven't quite said it in your own words, you sent that document to Mr. Hall to say, hey, I transferred this well to another operator at this point in time. So at that point, I was not the operator anymore.
Well, yeah, that was absolutely that was why I wanted to. That's why, yes, I guess definitely I should have made that point, but I'm not trying to skirt responsibility.
I get it.
Okay.
Okay. So
yes, that was
now, Mr. Hall, the rules. Okay. Thank you, sir. The rules. So under the rules, when Mr. DeLong transferred ownership of this well, it's a single well, right? Single well. When he transferred to this other operator, I think he said the name, but I didn't catch it. Was he supposed to report that to the OCD?
So the procedure, yes, sir. The procedure, and I appreciate, again, we're sympathetic to
Sure.
DeLong did this transaction, and then it wasn't formalized with OCD.
What should he have done?
What he should have done is make sure that a C-145 there's different ways to do this. C-145 is a transfer of a well to another operator.
Hmm.
There's also, if DeLong were bought by L&J
Yeah.
Oil, then that wouldn't even have to happen.
Okay.
It's just they're a subsidiary or, it's a corporate entity under the L&J Oil umbrella. So those are a couple of the ways that I'm aware of that responsibility for a well could be transferred, but according to he is the registered contact. He is DeLong LC is the operator associated with this well, and so again, we don't get into determining title
Okay.
or ownership of wells. We simply go by who is the registered operator.
Thank you, Mr. Hall. So, Mr. DeLong, what it sounds like is that when you did transfer this well to the other operator, you should have filed a form with the OCD to tell OCD, hey, I'm not the operator anymore, they are. That sounds to me like what went wrong here.
Yes, sir. And I'm pretty sure that we did do that because I'm familiar with the C-145.
Oh, you're saying you're pretty sure you did do that.
It's been yeah, because I mean, I know the procedures. I've purchased wells and I've sold wells. And so the C-145 is, you can either do it on paper, but I just, I might be able, I don't know if you guys can go back in, but I'm pretty sure that we went online and submitted to OCD. And I don't know if they could go back into that time. I don't know that we may have it in a file somewhere, but it was moved to Texas and they were not, they're not probably the most organized files whenever, it's not like our files now where we're currently working out of it. There may be copies where we did do that. So
I understand what you're saying. So it's not the burden of the OCD to find evidence. That would be your burden. If we have a hearing and OCD says, hey, this operator has been inactive since this date, then it's up to you to say, oh, here's a piece of paper, or here's some sort of evidence that no, I did file that C-145. So that's not something that we would do, or it's not we, it would be the division whose case this is. It's not something that the division would do. It would be something that you would do. Now, you did have a 30-day period at least to sort of try to resolve this case. And if there was some sort of evidence that you did file the C-145, that would have been a good time to have given it to Mr. Hall to say, hey, we did it.
Understand.
Are you?
And the reason was because the wells are in violation of financial assurance and active wells report. And so this occurred on August 17th of 2022. So it was rejected.
Did you know that, Mr. DeLong?
I can't understand what Mr. Hall is saying.
Mr. Hall said that, yes, there is a record, and I don't think this is really Mr. Hall's burden to show, but he went and looked based on what you said.
That.
Of course. Well, we try to give the respondent every opportunity we can here. He did look, and he found that a Form C-145 was filed. The problem is it was rejected. And it was rejected because the financial assurance wasn't in order.
Okay. I don't know the details of that.
Are you able to hear Mr. Hall?
Does it mean that there was not it means that there was not a bond, or
hold on, Mr. DeLong, hold on one second. Mr. Hall, will you say something? I want to see if Mr. DeLong can hear you.
Sure, I'm still muted. So
can you unmute? Okay, will you say something now?
Yeah, can you hear me now, Mr. DeLong?
Yes, I can hear you.
Would you explain what happened there?
Sure. Looks like August 17th of 22.
I haven't seen this until now, but I just looked back through, the operator actions file, which is public record, but, the wells and, the C-145 was rejected, and I'm just gonna quote, the comments associated with that. Wells in violation with the financial assurance inactive wells report, inactive wells list has exceeded, 1915 compliance, which means there were too many wells that were inactive. I think probably because it was one well, and that was showing up as inactive whenever the C-145 was done. So that's the status there.
All right, I didn't
Could
understand
I say
any of
one
that.
more
That
thing,
was,
Mr. Higgins? Again, if Mr. DeLong can effectuate this and show someone else is responsible, we're willing to work with him on
Okay.
that. We're not out to get
Right.
anybody. We understand he's made efforts, but the rules are the
Right.
rules. And so right now, this is where we're at.
Right.
But even post-hearing, if he wants us to review a new C-145 or some kind of agreement that L&J is also part of, I haven't checked their
Right.
compliance status. So these are all
Okay.
kind of hypotheticals. Just want Mr. DeLong to know that we want wells to be in compliance. And if he makes efforts to make that happen, we're not out to get him. We just want this well compliant. And right now, he's the responsible party.
I understand perfectly. So, Mr. DeLong, it sounds to me like even though by
Sir,
the
I
letter
can't-
of the law,
can you hear me okay? Can you hear
well,
me
I was
okay?
I was speaking. I can hear you, but I was speaking. So why don't you wait till I finish?
Okay, sir.
All right. So, Mr. DeLong, even though by the letter of the law, you are the responsible operator, based on the rejected C-145, Mr. Hall didn't know about that rejected C-145, and it sounds like he's willing to work with you to try to resolve this case in some alternative method. But I'm going to put a time limit on that. I'm not going to let this go on for a long time. Okay.
Understandable.
All right. So, Mr. Hall, how much time are you and Mr. DeLong, how much time do you foresee this going on?
I would like to ask Mr. DeLong how long he wants for that, and then I'll let you know whether I think that's a reasonable amount of time or not.
Go ahead.
If that's
Go
okay
ahead.
with you.
Well,
First, I want to know how long he needs
to try to. Right. So ask him.
Okay. Oh, Mr. DeLong. Oh, sorry. I'm used to. Okay. Mr. DeLong, how long would you need in an effort to try to get in touch with L&J or whatever your plan is to get this well transferred or to deal with the bank and make sure that it's either produced or plugged?
Okay, Mr. Hall, I'm getting a tremendous amount of echo. I hear the other gentleman perfectly, but yours seems like it's echoing. But I'm guessing that you said how much time would I need to finish the tank?
Yes.
Probably the end of the week. I had some tanks shipped down from from Texas. They're setting in New Mexico right now, and I've got to get over there and see to it that they get put in. But the well is pumping, and I mean, I started working on it immediately.
Mr. DeLong, hold
Yes.
on a second. All you needed to say was the end of the week, and that's perfectly acceptable. Yeah, exactly. We don't need the long story. The short story is enough. That's perfectly acceptable to Mr. Hall. So here's what we're going to do. We've had the hearing. I've heard the division's evidence. I've heard your evidence. At this point, you are liable for this one non-producing well according to the rules under the Oil and Gas Act. Mr. Hall does have the right to submit a final order, and I would actually sign it. However, to really bend over backward for you, we're going to give you till the end of the week to do whatever it is that Mr. Hall needs you to do so we can have an alternative resolution. Do you understand?
Yes.
Okay, wonderful. Mr. Hall, is there anything else?
Yeah, just logistically, if you don't mind, I will tell Mr. DeLong.
Yes, please.
Just give me that info. If it's producing, what we'll do is what's called a stipulated final order that that's your deadline. And if everything's compliant with that well, I understand you may have issues with the bank or L&J about whose oil that is. But if the well is producing, we're satisfied. Then it's no longer an inactive well. And you'll admit the violations and we will execute a stipulated final order, laying out those violations, but also giving you however much time you need based on what I hear Friday to get it produced. In other words, if it's already producing, then we can just say that's happened, you admit the violations, but we'll agree on the amount of a civil penalty. And then Mr. Chikalen will not have to enter an order. We'll do it between you and OCD.
Okay, well, I guess I'll call David Alvarado, the inspector with the NMOCD, and have him meet me out there and then just have him verify it.
Great. And then, of course, C-115s will need to be filed, evidencing the production amounts.
Yep.
I know you're aware of that, but I'm just letting you know that would be part of
I'm
the
well
work.
aware of that.
All right, Mr. DeLong,
gentlemen, thank you.
Anything else, Mr. DeLong?
No, I mean, it was pretty, if it's okay, I'd like to talk to Mr. Hall, just on the telephone without the echo and everything like that, so that I can make sure that we were on the same page, if that's acceptable.
Of course it's acceptable. So why don't you, Mr. Hall, do you have a phone number or are you going to call him?
He has one.
I've got his phone number.
All right, very good. So then it sounds like, Mr. DeLong, you don't have anything else here on the record today.
No, I don't.
Very
have
good.
anything for the record. Thank
Mr.
you.
Hall, do you have anything else?
No, thank you for your attention.
All right. So, Mr. Hall, if things work out with Mr. DeLong, then you're going to go one route. If they don't work out for whatever reason, then you'll you'll send me a proposed order to sign.
Exactly.
Okay, perfect.
You'll have an order to sign or review anyway, one way or another. It'll either be dismissal based on SFO or a final order for this NOV.
Very good. All right, Mr. DeLong, I'm glad that you could finally join us because it did benefit you to join us.
All right, thank you. I appreciate it.
All right, we're off the record.
Mr. Hall, I'll call
for
you shortly. Are you, Mr. Hall, are you finished now?
I think this
Should
is
I call
the
you
last
later in the day?
Give me a little time to get upstairs. Would you call me in about 15 minutes?
I'll call you about 3 o'clock today then.
3 o'clock? Okay. How
How about tomorrow? How about I'll just call you tomorrow? I'll call you tomorrow.
Sounds good.
All right, thank you.
Okay. All right, thank you. Goodbye.
All right, we're off the record. Mata E, will you stop recording?